President George Washington first published his farewell address to the American people 227 years ago today, September 19, 1796, in the Philadelphia Daily American Advertiser. He explained that the Constitution can be changed only by, quote, an explicit and authentic act of the whole people, unquote. That act, defined as in Article 5 of the Constitution, is ratification by the three-fourths of the states of a proposed amendment in the manner Congress has specified and within a deadline that Congress has set. Under Article 5, amendments may be proposed by two-thirds of Congress or by a convention called by Congress upon application of two-thirds of the states. Each of the 33 proposed amendments in American history has come from Congress. The states have ratified 27, 4 proposed without a ratification deadline are pending before the states, and 2, the 1972 Equal Rights Amendment and the 1978 District of Columbia Voting Rights Amendment expired when their deadlines passed with insufficient state support. Congress has 3 powers in the constitutional amendment process: proposing amendments, setting the mode of ratification, and, according to the Supreme Court in Dillon versus Gloss, imposing a ratification deadline. Congress proposes an amendment by passing a joint resolution with 2 parts: a proposing clause containing procedural rules, such as the mode of ratification and any ratification deadline, and the text of the proposed amendment. Congress has proposed 10 amendments with a ratification deadline, placing it in the joint resolution's proposing clause of 5 and in the proposed amendment's text for the rest. The validity of a ratification deadline depends on Congress's authority to set one, not on where Congress chooses to put it. The Biden administration's Justice Department agrees. Last year, it defended the Archivist of the United States against a lawsuit by Illinois and Nevada trying to force him to certify the 1972 ERA as the 28th Amendment. The Justice Department's brief in Illinois versus Ferriero noted that, quote, members of Congress did not ascribe any substantive difference to the 2 types of deadlines, unquote, and that substantial historical practice supports Congress's authority to decide where to place a ratification deadline. Turning to the alternative way to propose amendments, in the 1787 convention that produced the Constitution, the framers sought to give the states a way to initiate amendments before, by compromise, they gave that power to Congress. An Article 5 convention is an interstate convention, what the Justice Department's Office of Legal Counsel has described as a, quote, servant of the legislatures, end quote, rather than an independent body. Its powers, therefore, are defined by the states expressed through their applications for a convention. In deciding whether it must call an Article 5 convention, Congress must be guided by the fact that the framers did not want Congress to interfere in the convention process. A February 1993 House Judiciary Committee report reviewed many of the questions that Congress must consider in that light, including whether convention applications that specify a particular subject may be counted with those that do not, whether applications that specify different subjects may be counted together, whether applications must be worded identically or be relatively contemporaneous, and whether states may rescind or withdraw an application before the 2/3 threshold is reached. Current campaigns for an Article 5 convention appear to be taking steps to minimize conflicts over these issues. The Convention of States, for example, advocates that states pass an identical application limited to proposing amendments that would impose federal or fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for its officials and for members of Congress. I have included with my written statement a new legal memorandum published by the Heritage Foundation last Friday that discusses many of the issues that I've touched on today in the context of the 1972 ERA. Thank you again for the opportunity to testify today, and I look forward to answering your questions.